Hello again, this is Dabney Beasy. Your General Assembly preparation continues on the Westminster Standard Podcast. This week's episode examines several overtures that propose changes to the judicial processes of the PCA. These potential changes could have a massive impact on the way the PCA operates. I hope the elders in Richmond will consider them carefully so that the PCA can be preserved in faithfulness and truth for generations to come.
This is the Westminster Standard Podcast. I'm Ryan Beasy. I want to welcome today Teaching Elder Stephen O'Neill and Teaching Elder Jason Piland. We will be discussing some of the process overtures that are before the General Assembly today. There are, of course, numerous overtures to be considered by the Richmond Assembly, and the large portion of them deal with the process or the procedure that we are to follow as a church when we conduct ecclesiastical trials. So welcome, gentlemen. Thanks for giving up some time to talk about this today.
Hey, it's great to be with you, Ryan.
Yeah, thanks for having us, Ryan.
Likewise. Well, Jason, this is your first time on the show. Why don't you give us some background? How'd you come to the PCA? How did you get to be where you are?
Yeah. Thanks. Thanks for having me. It is great to be with you. I'm a longtime listener, first-time caller. So I grew up in Napark. Grew up in the ARP in North Carolina. And my family helped plant PCA Church and an OPC church in the Hickory area of North Carolina. But we ended up landing back in the ARP. And so I consider the ARP my home church. I went to Nashville for college. And when I did that, I got back in the PCA and have been in the PCA ever since. And so I went to RTS Charlotte after being in Nashville for about 10 years, went to RTS Charlotte. And then now I'm up in Ohio in the Ohio Presbytery at Redeemer Church, the associate pastor up here, the clerk of our presbytery as well. And so it's just a joy to serve the flock up here. I've been married to Erica for, I think we're coming up on 12 years. We got 4 kids. So life is very full right now, and we're very thankful.
Well, thank you. And Stephen, you're still in New Jersey?
Still in that great bastion of Presbyterianism.
Yes.
Yeah. Everyone in the PCA, you can just say thank you to New Jersey, because even though PCA is a Southern church, people still love Old Princeton, and rightfully so.
Yes.
It was just I was just in the parking lot of the Princeton Seminary Library because I needed to make a phone call about 30 minutes ago.
Wow. Was that to get a professional to fill your car up with gas by any chance as you were in the...
One of the glories of the Garden State is that in the dead of winter, someone else is standing outside filling up my car while my heat is blasting, my music is on, my family is content. Wow. It's a great thing.
Amazing.
A man of privilege. What can we say? Well, before we get further off the rails, let's dive into Overture 1. Overture 1. We've discussed this previously on this program a number of times, but I don't know if we'll have discussed it at greater length. Overture 1 and its parallel, Overture 18, would allow witnesses who are atheists within church courts. But Overture 1 has a serious defect noted by our Committee on Constitutional Business. Jason, do you want to walk us through some of the defects of Overture 1?
Sure. I think you've said it well on the podcast previously. So I'll try to recap kind of what CCB said on that. I am on the Committee on Constitutional Business for the General Assembly as well. So we met and considered this overture. And you have the language up here, and I'll read it and then expand on that. It says, in the opinion of CCB, because CCB only provides opinions. We don't provide definitive rulings any longer on anything. We just give our opinion to the Overtures Committee on overtures and what their effect on the Constitution would be. And we said this is going to be constitutionally vague, which means we don't believe there's a constitutional way to actually apply it. It is so vague that it's impossible to apply. In that it provides the mechanism of objecting to witnesses for incompetency. Even though the amended language does not use the word incompetency, without providing courts any apparent rule to guide their ruling on the objection. And it really comes back, if we look at Overture 1, to the language. The final sentence says, either party has the right to object to a witness, and the court shall consider and rule on the objection. It says that when in the previous sentence, it basically just said everybody can be a witness. However, everybody still has the ability to object to any witness they want, and the court's going to rule on that objection. The problem is, if everybody can be a witness, what guides the court in ruling on that objection? And what CCB said is there's no guidance. It says you can object and there's going to be a ruling, but what is the rule that you're applying to this situation? And so what we're saying is what CCB has said is that this is vague, that you can't even apply it. Every court will make its own rule, and it could be arbitrary, capricious. There's nothing here to guide a court and say how you make this determination on whether somebody can stand to testify or not. And so that's really what Overture 18 is trying to correct, is to take that part out of Overture 1 and to leave basically the rest of it intact, so there's a better option for the GA to debate. But I don't know if that makes sense, or if that was a clear explanation or not. What do you think?
That was a better explanation than I had proffered on this program. So thank you. So I think what you're saying is there's just too much discretion to any court. We don't like judicial discretion, I think, generally.
Yeah, and so discretion is not necessarily a bad thing, but in a case like this, where this is getting to an essential element of a trial of who you're calling as a witness, you need to be able to know what the rule is for what witnesses are allowed to testify and which ones are not. And it's ambiguous here who's allowed to testify or not. It could be the whim of the court that day can decide, if you wear white shirts, you're not allowed to testify today. Okay, where did that come from? Conceivably, something that ridiculous probably wouldn't happen, but it could happen under this language here. There's nothing hemming in a court in any way. And so what this could actually do for the makers of Overture 1, they want atheists to be able to testify. What this could actually do is limit atheists from testifying. It could limit anybody who's not PCA from testifying. The court can decide how broad they want to make this. And so every court would apply it differently. So discretion, there's a lot of discretion in many ways, but you're right. In this kind of situation, we don't want there to be a lot of discretion. We want people to know what to expect when they show up for a trial. We don't want them to show up and there to be arbitrary rules laid down by the courts.
That sounds reasonable. Stephen, anything, I think you were on last time we discussed this, or at least in the fall, 6 months ago. Anything since that discussion that you want to add?
Well, I think just as Jason's on here, I'd appreciate if you had any thoughts on, because I was thinking this through this morning, with courts being in this version of the amendment, or this particular overture on this topic, courts being given very broad leeway to sort of rule that certain people's testimony should not be admitted. How would the ordinary deference that higher courts yield to lower courts on this matter play into it? Because from what I understand, there's different standards of deference that are owed, like constitutional questions, there's less to almost none. Matters of fact, there's very, very broad deference that's owed. So how do you think that would play in if this version of the amendment were to pass?
Right. So you're talking about 39.3 that lays the standard of review for when a higher court's reviewing a lower court. So your hypothetical is, what if there's an appeal or a complaint against a court's ruling on this, likely an appeal?
A person says, I don't like that the court excluded this person's testimony.
Right. Exactly. Which actually is listed in BCO 42 specifically as one of the grounds for an appeal, is that they did not receive proper evidence. But the question is, what's proper? And the BCO does not guide you here on what is proper and what is not. It just says the court has to rule on it and does not give any guidance. And so there is no deference given to lower courts on interpretations of the BCO. But the problem is the BCO doesn't tell you what to do. There's no real way to interpret it here. That's why we said it's constitutionally vague. And so, yeah, the great deference would likely go towards courts, and the language here would be clear error. It'd have to be established that there's clear error. But if this is left to the discretion of the court, it'd be very, very difficult to conclude that there's clear error. It would have to be something completely arbitrary and capricious, like white shirts are not allowed to testify, something like that, for the higher court to say, no, that's totally unreasonable. But like if they said, no, if you're not a member of a PCA church, you have to be a member of the PCA to testify, I don't know that a higher court could overturn that. I'm not sure. I haven't really thought through that much. What do you think?
Yeah, what I was just thinking is because right now, if someone were to, complain against the decision of the court or to appeal a decision on the basis of sort of excluding sort of testimony, really, there's only 4 reasons that someone could be deemed incompetent to testify currently.
Right.
Age, intelligence, atheism, and I guess universalism is a way of putting it. And if it's not one of those 4, a person is required. You're required to allow them to stand.
That's right.
And
That's
judge
right.
the quality of their
Mhm.
testimony,
Mhm.
as opposed to just forbidding them from doing so beforehand. So there's clear
That's
rules
right.
now as to who can and cannot testify.
Yes.
It could be lost under
That's
this.
right. Exactly. And Ryan, to your point, where discretion comes in, though, is how does the court judge this witness? And that's where BCO 39.3, you give great deference to the lower court in determining credibility of witnesses. And so even if somebody testifies, doesn't mean that the court has to believe them. It just means they have to hear what they have to say. So the court has great discretion in determining, yeah, this person's a liar. We're not going to listen to a single word of what they said. We're going to believe the other witnesses over them. So there is discretion on that's called credibility. What do we believe? Are they credible? But I don't think in our legal tradition, at least, we don't give a ton of discretion on competency. Who is competent? Who is allowed to take the stand as a witness? Period. Now we might not believe them; they might not be credible, but they have to take the stand. But actually, even in our current BCO, there's a little bit of discretion there. It says proper age and intelligence. What does that mean? The court will decide. Every court might come out different. It doesn't say if you're 6 years old and older, you're competent. Courts might come out differently on cases of a 6-year-old or 8-year-old coming to testify. And intelligence, typically that means insanity or something like that. That's historically what that's meant. But courts will come out differently in different situations there. And I think a little bit of discretion is okay, but not that ultimate discretion where you can do whatever you want.
Yeah, this just seems to me to be so ill-conceived, and the fact that it was submitted twice, right? That this isn't even the first time that this language is before us. They got feedback, and then they're still sending it up with these critical defects, fatal defects. And so that's why the top Presbytery in the Presbyterian Church in America has come up with its own a version of this principle, though I don't know if even the majority of the presbytery was in favor of the principle. From what you said, Jason, it sounds like your presbytery thought there was a need to offer a solution to this desire, even if you're not in favor of this solution. Can you explain that better than I just did?
Yeah, so I will say people up here from the Ohio Presbytery would rather it be called the Ohio Presbytery, just for the record. Top works for others who are not from Ohio, but people up here they really like that, the Ohio Presbytery. But yeah, I will say Overture 18, the second sentence of the rationale, it says, by making this overture, the Ohio Presbytery does not comment on the substance of Overture 1 in expanding witness eligibility. So what's going on here is it's identifying an issue and trying to fix that. And it's not actually saying it's agnostic on the substance. It's saying, let's get a better proposal where we can actually then debate the substance. So at our presbytery, we did not go into substance at all. We didn't go through the pros and cons of atheists testifying. We just identified the issue and voted to send this up as a better alternative. Even if people were not in favor of atheists testifying, they voted for this because we thought this was a better representation of what Overture 1 was trying to get at.
Wow, what a churchmanly thing to do. I recall others talking about that on an individual level. That I think Jared Nelson has talked about how Jay Nykerk has come up, fixed his motion, and then spoken against it, but said if we're going to consider it, let's consider a good version of it, the best possible version we can. So thankful to the churchmen in the Ohio Presbytery.
There you go.
Well, let's, if you're comfortable, would you explain how this overture tries to fix the defects of Overture 1?
Right. So what it's trying to do, and I'll say I was kind of the driving force behind this and wrote this text. So if you have concerns about it, talk with me. I'm not pretending it's perfect in any way. And myself on the substance of it, atheist testifying, I lean towards being in favor of it, but I'm still very much wanting to listen and to hear the best arguments. So hopefully I can hear some of those if you want to get into that today, Ryan. But what Overture 18 is trying to do is to take out that discretion piece. And what it does, so the text as you have pulled up here, a witness may testify only after making an oath or giving affirmation to testify truthfully. So the first sentence is all persons are competent witnesses. So it's basically saying everybody can testify. Once you make an oath or give this affirmation to testify truthfully, you can testify. And it takes out that challenge, that objection language, because if everybody's competent, the way Overture 1 really read, it didn't use the word competent, but it effectively was saying that everybody's competent, and then giving the ability to strike or to make an objection and then court to rule. That doesn't make sense. You either have a determination of competency and you can object and make the court rule on competency, or everybody's competent and you don't have that ruling. And so the way this is presented is that there's everybody's competent, and so you don't object. Everybody has to give this oath, give the affirmation, but you can't object on any grounds if they're making this oath and affirmation. If you do notice on let's see, there's a footnote 1 on the Overture 18. It actually provides an alternate option here. And I'll read it here. It says this: all persons of proper age and intelligence are competent witnesses, and a witness may testify only after making an oath or giving affirmation to testify truthfully. Either party has the right to challenge a witness whom he believes to be incompetent, and the court shall examine and decide upon his competency. Some feedback from some brothers was, well, why are we getting rid of the whole competency category? We need proper age and intelligence as a competency category. And if we're going to leave that in, then great, let's leave the striking language, but leave it based on incompetency only. And so it's very clear the way the BCA is written now, the challenges are based upon competency and incompetency, and the court rules upon competency for only age and intelligence. So in other words, it's really only striking that sentence about those who do not believe in the existence of God or future state of rewards and punishments. So kind of trying to give two options. Do you want to leave some categories of competency here that you can object to, or we're just everybody's competent and we're not going to have the objection mechanism in there any longer?
So this one, as it's before the assembly, now the overtures may revise it to that.
That's right.
To take the footnoted version.
That's right.
Would simply remove any discretion from a court on grounds of competency for witnesses. That anyone, you can bring in a 5-year-old to testify. You can
That's
bring
right.
in a 95-year-old suffering from dementia to testify, and then the court has to decide whether you weigh how to weigh the validity of that testimony, the
That's right.
truthfulness, the reliability of that testimony. Well, that's those are interesting proposals, and I suppose part of the conundrum of how to address this concern that atheists should be allowed to testify. I've said on this program a number of times that I think church courts are for church courts or for church people. Why don't you, Jason, give us a thumbnail sketch of why you believe atheists should be allowed into the church courts?
Yeah, so let me, I'll steel man the argument for you. If you heard this term steel man, like instead of straw man the argument, straw man to knock down, let's steel man it. Let's give the best representation that I can come up with of this argument. And again, personally, I'm still working through this, but let me steel man it and give the best argument that I know to see what holes we can poke in it if there are. And the best argument that I can come up with, and to me is compelling to a degree, is that what the job of the court is in a trial. The job of the court is to find the truth. It is a finder of fact. It is trying to determine what happened in a particular case. It's trying to look at all the perspectives, all the views, and come to a determination of this is what happened on July 1st, 2020. It's going to find the truth. They are a truth-finding entity. And so when you're trying to find the truth, you need to bring all the relevant information to be able to make that determination. And so I think if I was an accused in a case, somebody said, hey, Jason is embezzling from the deacon's collection box on Wednesday afternoon. And the only person who can help me with that is the clerk at the grocery store who checked me out. She said, no, he was here and I saw him. He was walking around the store and I checked him out 5 minutes later. If that's the only person, that person's an atheist, I want that person to be able to testify for me. I want that person to show up to the trial if that person is willing to, and that's an issue. There's no way to really compel them to show up. But out of the goodness of their heart, if they want to help me in my case, they can show up and say, no, Jason was walking up and down the aisles getting stuff for sandwiches for his family for dinner. And I think the court needs to have the most information that it can have about that. And I don't see that barring atheists allows them to have all of the information about a particular situation. And so from the point of view of a potential accused person, I would want to make use every avenue possible to make my defense. And if an atheist is one of those, great, bring him in. Now, the prosecution can then cross-examine that person and show holes, say, well, do you believe in God? Do you believe that if you lied today, there are any consequences? And the person would say, well, I guess not. Then they can make an argument to the court, well, you shouldn't believe this person because they don't believe there's any punishment for lying to us here today. And that's, again, for the court to determine, do we weight this or not? Is this credible or not? But that's a question of credibility, not competency. This person, I think should be able to show up and testify for me. So that's where I come down. The church court is a finder of fact. And if I can put another voice in here to help them come to the truth, I want to be able to do that. I'd be fascinated to hear your response to that.
Yeah, that I am certainly sympathetic, and I think as a principle, our courts need to favor the accused as far as anybody who has rights. Before a church court, the accused needs to have the most rights because it is a grave sin to convict the innocent.
That's right.
And I know that the prophets will rebuke Israel for not convicting the guilty, but I think that the weight is on the those who will convict the innocent. But I would just take issue that with your example that embezzlement is a crime. And so if there's if those facts need to be determined in something like that, call the civil magistrate and let the civil magistrate sort out the facts of the case. And then after that is done, we can come alongside and inflict any censures that are necessary, which would not require bringing an atheist into our church courts. And when we remember the aims of discipline, of course, the glory of God, the purity of the church, and the reclamation of the sinner, this then allows us to slow down that process. That if we were to need atheist testimony, we say, well, let's just wait to see what Caesar does in this case, as the one invested with the power for punishing that sin, and then once he's rendered his judgment, we can then apply that. For our own use and the different purposes of a church court.
Yeah, I think that's helpful, and I would agree with you that the church shouldn't first be the first finder of fact in a case like that where there's criminal investigation and criminal proceedings going on. I agree with that. So my question though would be, how would that civil or criminal judgment come into the church court? Like, show me the nuts and bolts. Like, walk me through that process. How would that work?
That would be evidence. Right, it wouldn't be testimony, which could be evidence, but it's material evidence. It's you were found guilty of this crime. Here's the transcript of the trial. Here is the jury instruction that the jury was given, and they found you guilty of it. Because you're a lawyer, so, or you were. Maybe you're still a lawyer. I don't know, but you know this better than I. That the jury instructions are often more clear than even the statute. That in order for a person to be guilty of this crime, the state must have proven these three things. And so then you bring that to a church court and say, well, look, the jury found that you did these were the circumstances. And then you let the person respond to that. Still that, because sometimes jury instructions are just bad or laws need to be nullified, and the jury failed to nullify the bad law.
Right.
So, I would certainly allow that a person might be convicted in the civil court, but the church court might look at that and say, well, we just think this was an injustice. So it would come as a form of document, as evidence. And then that really saves the church court time. Yeah. And she can invest the time and effort that she would have spent in being the first one to charge in shepherding and discipling this person.
Sure.
Would be my argument.
And I think in a case like that, that makes a lot of sense. If you have a case though, where it was, I have a habit of stealing Pop-Tarts from the grocery store or something like that. Or you think I do, right? Maybe the civil magistrate isn't going to prosecute it. or a case where I didn't do it and you think I did, and I have to bring now testimony in because the court's not going to prosecute me for it because they don't think I did it. Just the church thinks I did it, and now I'm defenseless because there's no civil or criminal case to bring in. So I would still need that evidence from someone, and here it happens to be an atheist who can provide that evidence. So I see what you're saying, but I don't think it applies to all the cases that could come up. So,
but even that, I would have to prove. I can't just contend. And I think that may be something that's also missing from this argument, that simply because I think that you did something, you don't have to prove your innocence. Which is, I think, something that we often forget.
Yeah, that's right.
That simply because someone makes a claim about somebody doesn't mean it's true.
That's right. That's right.
Stephen, anything?
Yeah, I mean, I think that I've thought about this topic, I guess, since last assembly when it was first brought up to our attention. I'd say that I can be convinced otherwise still, but I'm pretty on the side of I don't think atheists and universalists, and I think that inclusion is important because most universalists, Christian universalists, can swear the oath that is present in the Book of Church Order. So I do think that inclusion is pretty important, pretty key for our understanding of actually how this section of or why this provision is actually in our book. But anyway, I'll get to that in a second. But yeah, I'm skeptical of the need for atheists to testify. This arises from just a general skepticism toward like BCO change, like changing the way that commissions work. My presbytery is one of the few that oppose that, and one of the reasons was because I stood up and said that we don't need to do this, and gave reasons for why we don't need to change the book in that matter. The statute of limitations, Mr. Piland gave eloquent speech trying to not change that for good reason. I sort of had similar thoughts on that front. So unless there's a compelling reason to change something in the book, I don't want to change the book. Change the rules all the time, because the rules are much easier to change. They're not the actual Constitution. But so I'm skeptical of changing the book. Overture 18 didn't really give much substantive reason for its existence other than there are defects in Overture 1. So I looked at Overture 1 for sort of the strongest arguments of people who would propose this change, and I just didn't really find them particularly convincing. One of the reasons for that is that I think that there's I'm not sure that American society has become so atheistic that we need atheist testimony. For example, like if we were in a country like the Czech Republic, where the majority of the people in the country would not profess belief in God. Like still something like high 80s, low 90s% of Americans still profess belief in God. Polling on heaven or hell, or rather, that's not what, there is polling on heaven or hell, it's in the 60s, but heaven or hell is more specific than some sort of afterlife that involves punishment and reward. So there's still some substantial fraction of the United States population. And I guess I'm excluding Canada here. I don't mean to do that, but I am more thinking in my context and other contexts. And there are parts of the United States that are more atheistic than others. But I've yet to see examples of cases where this would have been determinative. And I would like to see examples of cases where this would be determinative before moving forward on this topic. Because otherwise it's fixing a problem that might arise. The problem hasn't yet arisen in my knowledge, and I'd like some demonstration that's happened before. I said before that I'd get to sort of my focus on universalists, in thinking through, why I think sort of dispositionally I'm sort of also in favor of prohibiting atheist testimony. It's not really sort of it's more of a practical reason, and it's not that all atheists are liars all the time. There was a line in the rationale for Overture 1 that implied that some people were sort of arguing that, and I hadn't heard that argument, or that atheists couldn't ever be trusted to tell the truth, when in fact, they tell the truth all the time. I mentioned certain countries in Europe that are very atheistic. They're very well run, very low corruption places. Clearly, a lot of people telling the truth regularly. The issue, the analogy with which I'm thinking through this overture, and this might seem a little silly at first, but trust me, it works, is how blood donation works.
I gotta hear this.
In general, we want the American blood supply We want to have as much good blood as we can have. Just like in a court, we want to have as much good information as we can have. But there are reasons for which we might restrict certain populations from donating blood. And until maybe 3 or 4 years ago, if you lived in Europe from 1980 onward, for a certain number of months, you were forbidden from donating blood. There was a yes or no questionnaire, and if you checked yes, then they'd say, sorry, you can't donate blood. And it was for fear of the basically human form of mad cow disease entering the blood supply. And mind you, there have been a couple hundred cases of mad cow disease in the world. It is the least likely thing to possibly happen, and yet hundreds and thousands of people were restricted from donating blood because of the slight chance that a sort of bad thing would slip through. Because that would just destroy the integrity of the system. People would no longer trust the blood supply because this one thing happened to someone, and it's terrifying. What if it happens to me? Can I receive that blood? People would start refusing, and people would start dying, and the blood system would sort of lose its credibility. And I think one of the reasons for keeping the prohibition on atheist, but more importantly, universalist testimony is that there is an ever so slightly increased chance that the person testifying, they might deceive very, very outwardly, tell a total tall tale. That's possible. But I think they're just simply much more likely to stretch the truth a little bit, even without intending to, because they don't have that strong guard of knowing that, of believing in their heart that God will judge them for what they do. I am always tempted to sort of exaggerate things in, storytelling, whether it be with my kids, with family, with people at church.
Or blood donations.
Pardon?
Or blood donations.
Exactly. And that's not great. To do. And in a church court, I should be particularly hesitant and particularly restrained in my temptation toward exaggerating anything. I've watched enough Law and Order SVU episodes, which might not be accurate, to know that people are sometimes, when they're testifying, they're under a bit of pressure. There are people who are examining them that are trying to get them to slip up or say a particular thing. And I see the belief that God will hold me to account for what I say, that I hold, not that I just have been told, but that I believe, as a really strong bulwark against slightly stretching the truth. Yeah, maybe that was a little bit worse than I initially thought, or actually, no, maybe it wasn't as bad as I thought. Because I think those are the ways where I think the atheist testimony are going to change the court more than not. Not so much the huge lies or conspiracies by atheists to undermine the court. That's possible. But I see it as the much more practical way that, a little bit of slippage here, a little bit of slippage there. And if this happens enough, then I think the trustworthiness of our courts is going to be damaged. Some might say that our courts' trustworthiness have been damaged by various things. That may be true. I just don't see compelling reason to change the book again to this additional form of damage. It's very, very unlikely. And that's why I do sort of like the blood example, because the chance of you getting mad cow disease, or the human version of it from blood, was astronomically small. Yet it was deemed very wise to do since from 1980 until maybe, was it roughly 2020, almost 40 years. And absent compelling reason, they didn't change. I think one of the reasons they changed is because they need more blood. I don't see the reason yet that we need more testimony. And until we see that, then I'm probably going to be on the side of the fence of not yet atheist and universalist testimony.
Yeah, I think that's a fair point. Yeah, if it's, yeah, I agree.
Well, Jason, thanks for your steelman argument, and Stephen, thanks for being more articulate than I am to make the case.
I was thinking about blood a lot. I was like,
well, in New Jersey, I guess y'all see that a lot.
Yeah.
Well, let's move on to Overture 4. How about that? This one's been discussed a lot, but basically, as I understand it, Overture 4 is suggesting a moratorium on changes to the rules of discipline and appointing a super committee that will come up with a bunch of changes on our behalf, and they've already selected who's going to be on that super committee, which pays its own expenses. which I think the CCB said was unconstitutional or out of accord with the RAO, maybe not because the RAO is not part of our Constitution. But I would be curious whether y'all have an appetite to wait on any ROD change and seek a super committee to do this for us on a professional level.
I mean, I don't particularly support this overture currently, I would say. Given, I think that, there is some strong desire on the part of the Assembly, in particular, to sort of hammer out this atheist and universalist testimony matter. And I think, we have 2 overtures to that effect now. One of which I think makes a very strong case for it. And there was, a very robust debate last year on this topic. I would suspect that the Assembly would rather continue that conversation rather than punt it to a committee for another year. So I don't know if there's going to be as much appetite for delaying on that topic as maybe some of the others. But more broadly, I'm not super happy with the idea of a presbytery picking a committee itself. Presbyteries are small. They're sometimes a bit insular. The New Jersey Presbytery is not big, and it is different than a lot of the presbyteries in the denomination. And the committee that we might select might not be the committee that people in Ohio or Tennessee Valley or really anywhere else in the country might want. And so, I thought there's wisdom into the Assembly itself, if it wants to do something like this, picking its own committee. So I have no personal appetite for punting all judicial overtures to a committee. But if we did do that, I would want the committee to be the Assembly's committee, not a particular presbytery's committee. And if that was accomplished by, having a special meeting of the nominating committee or something like that, or by having just the moderator be wise in his appointment of members, which in past study committees, it seems like the moderator does a pretty good job of that. I might prefer that to what we have in front of us here.
Yeah. No, I think that Central Indiana has done a yeoman's job at trying to come up with a balanced committee, but I agree with you that I don't like the lack of latitude for a moderator for the Assembly to pick its own committee. Jason, anything?
Yeah, no, I think those are really good points. And I hadn't thought about the presbytery, selecting the committee point. And I think that's very strong to me. So, okay, so say if somebody amends this, the moderator selects a committee. Let's say we figure out the financial piece that CCB identified. Is this a good idea? And I think at the end of the day, the question is, does Overtures want to work through these issues this year themselves, or do they want to punt? And I think the real question will be, do they want to work through Overture 20? Do they want to work on it? Do they think it has helpful things? Do we want to improve that and present something to the GA? Because if we do, then probably Overtures can't do it. And so we need the committee. If the Overtures committee, I'm not on Overtures, the Overtures committee decides we don't want to do Overture 20, then I don't know that there's a need for this. Because there are a number of rules of discipline amendments, but I don't think it's overwhelming. I think once you start getting into Overture 20, which how many pages, 30 some pages long, I think that is overwhelming, and I'm not sure the Overtures committee can do it. So I really think the question is, does the Overtures committee want to tackle Overture 20? Do we think it's worth looking in and diving into and seeing what out of that we can use? Or do we kind of want to send it back and decide, okay, hey, maybe bring the best ones to us in the future? I think that's really the question, because if we don't have Overture 20, I don't think Overture 4 is necessary. I don't think we need this committee. But if we have Overture 20, then we definitely need a committee who's going to work through that for the next year. I think that's my general take.
Yeah, and I don't see the Assembly taking up Overture 20. I didn't even plan for us to discuss it because it comes from a session, and right. I don't know the last time the Assembly took up something from a session. Maybe it was when it came from New Hope in Fairfax. I think there was something from their session. I can picture the debate, but I don't remember where that debate took place. Which assembly hall that looks very similar to every other assembly hall. But yeah, did you all want to discuss Overture 20? I didn't make slides for that, but if you do, I just skipped the ones that were from sessions or individuals. I thought that's just
right. No, and I think one of the arguments though for 20 is 20 is not in the shape it needs to be in. And so let's get this committee to put it in the shape it needs to be in. And so is that compelling or not? I think is ultimately the question. I think personally, I would rather see the work done before it comes from a presbytery. To your point, it's coming from a session. I'd rather see the work done before it goes to a presbytery. Presbytery send up something that's pretty good and can be worked on by Overtures committee. So I think I'm probably against number 4 because I'd rather the work be done on the front end than on the back end. And so bring us a better recommendation next year on the key pieces here.
Yeah. And what the CCB said was Overture 20 is in grave conflict with the Constitution, not just conflict, but grave. Do you have a rubric that you all use? With review of session records, it's exception of substance or form or notation. So we only got really 3. Do you have if there's many points, it's just in conflict. That many points, it's in grave conflict.
Yeah, I don't know if there's. I'm not sure if grave conflict has any precedent. Frankly, I'm not sure that that's been done before. But I think it was a part of that was CCB didn't feel like we could go through it line by line, and so CCB just acknowledged a number of key pieces that are problematic, but saying this is not inclusive of all the problems here. We just want to highlight a few of them, and they're so systemic. We're going to call it grave. And not just a simple conflict that can be resolved easily, because most of these conflicts can be resolved pretty easily by the Overtures committee. Yeah. But those were so deep. But that's also the argument for the committee. Yes, we know there's issues, but let's have the committee fix them for us. So I think that's the question.
Yeah. And Stephen, have you served on Overtures?
I did last year. I decided not to go out for it again this year. I feel like I might try to do like a one-on, one-off year because it's pretty daunting.
Well, and that's the thing that, there should be this expectation that if a presbytery is going to send up an overture, that it's pretty well ready for prime time. Right. And perhaps that's why these overtures were rejected by Central Indiana, is that the presbytery said this isn't ready for prime time. This isn't even ready for the 2 a.m. spot on the upper UHF register.
Yeah, well, I think it'd be, given that there's people that have agreed to serve on this committee, I think it'd be very wise for either the session that sent it up or the presbytery to sort of solicit some input from them, just sort of in an informal way.
Right.
That would also serve a pretty similar purpose in getting the overture cleaned up and, as you said, ready for prime time. Yeah. I'm not, like I said, I'm skeptical generally of changing the book, but if there are problems, especially in the rules of discipline, then they should be changed. And
absolutely
really identify those problems and have, good, clean solutions to them.
Mm-hmm. Yes.
And that's something eminently worth considering.
Yes. And to be clear, Overture 4, which is the main issue we were discussing now, was approved by Central Indiana Presbytery. But as we touched on Overture 20, that was sent up by a session, having been rejected by the Presbytery. But just to keep things clear, well, let's move on to Stephen's penultimate favorite overture, Overture 7 from Ascension Presbytery. This is the Save the Stated Clerk from a Workout overture, I think. Stephen, you want to give us the background to this?
Were any of you on overtures last year, or was it just me? Oh, I guess it was just me. But yeah, last year there was a overtures committee was starting, and pretty early on in the committee, someone made a motion that we take up a particular overture because it was properly before the overtures committee, but that overture had not been referred to the committee by the stated clerk. It had referred to, I believe, all of the committees of commissioners for permanent committees and agencies. And the overture sort of debated whether or not it was before us. The stated clerk made an argument that it wasn't, and that he didn't send it to the overtures committee for reasons dependent on RAO 11.5, and he offered an interpretation of that. Others offered a different interpretation of RAO 11.5 about which governs sort of how the stated clerk directs overtures received by the General Assembly, who gets to look at them and make recommendations on them. And so it became pretty clear just from that experience that there's some confusion on what RAO 11.5 actually says. And so I'm very pleased that a very obvious problem in process led to a presbytery proposing a solution to that problem, which is that's just the best way, I think, to sort of produce overtures. Like, a problem exists, people saw it. People experienced it. Let's try to fix that problem. And that's even how sort of like the whereases in the overture begins. Whereas RAO 11.5 is difficult to follow. And it mentions that at the 50th point, there was debate regarding this exact matter, regarding the interpretation of this particular section of the RAO. So I'm just pleased with sort of just the fact that this amendment exists, this overture exists. I'm pleased with, but I also think it handles things really, really well. I think there's probably a few areas to clean it up a bit. There's a few questions I have that I don't think are answered exactly by it, but by and large, it makes clear that overtures that intend to amend the BCO or the RAO, recommendations on those overtures are to be presented to the Assembly by the Overtures Committee.
Yeah, and you know that was what part of the issue was, that the state clerk was having to go to every committee of commissioners meeting at the same time almost to speak to this. And what this will do in paragraph C, that they go to the Overtures Committee and the permanent committees. So it might not save him from a workout, but it will at least clarify that, yes, the Overtures gets everything. That everything is before the Overtures. Am I understanding that correctly?
Yeah. So it's like if an amendment changes the BCO, or if an overture intends to amend the BCO, it goes to the CCB for a recommendation that they share with the overtures, and then overtures, debates, perfects, makes a recommendation. RAO amendments, they are also sent to overtures, but they also can be sent to the committees of commissioners, the permanent committees and agencies, and I guess special committees, if they're relevant. So if there's an RAO amendment that pertains to something related to perhaps let's say the college and the seminary, well then the college and the seminary will look at the overture and will be able to make recommendation on the overture, give advice to the overtures committee, exclusively the overtures committee, not to the Assembly but to the committee, so that they can deliberate on that advice and then sort of come with a recommendation. So it just simplifies the process. Last year on the particular overture in question, I think every permanent committee and agency made a recommendation on it, and most of them
to the Assembly made a recommendation to the Assembly. And the question then is, who's the first on the docket? Because they're the one that's going to prevail. And so it's a race to see who can get to the floor of the Assembly first, and they're going to amend the docket and get overtures first, and administrative committee first. Which one's going to come first? Now, so I'm sorry to interrupt you, but I think that was a good point to make, that now their advice is to the overtures committee. Only overtures committee brings that to the floor of GA. I think that's critical.
Yeah, and another thing that's in the whereas statements that's helpful is that the overture comes to the Assembly, and the Overtures Committee has the unique ability to sort of modify and perfect overtures. And so last year the Overtures Committee ended up with an overture that was slightly different than the one that the committees of commissioners considered and recommended on, because they're not given that same leeway to modify what presbyteries send up.
And minority reports are not permitted from committees of commissioners, but they are from overtures. So you can have a more robust debate about it if there's a minority report.
Yeah. So overall, just simplifies the process, makes it more deliberative, gives the Assembly greater power to debate and to provide options to the Assembly itself to vote upon. So I really hope that the Overtures Committee cleans up a few things here. But I'm hoping that this one will pass. I think it's a bit of a no-brainer.
Yes. Yeah, I agree. One thing that's interesting is that it's calling for the CCB to provide advice not just to, this is in the proposed 11.5a, CCB to provide advice not just to the Overtures Committee, which is the only committee that receives advice from CCB, but now to all the relevant committees that receive these things. So CCB will now have its own advice given to these committees that receive BCO and RAO amendments. But those committees do not bring recommendation to the floor. They bring it only to overtures. So overtures is the place for any amendments to the BCO and the RAO to come through. And this definitively says that. And I think that clarity is very helpful.
Very helpful indeed. All right. Well, are we ready to skip ahead to Overture 21?
Let's do it.
All right. Overture 21, another from Central Indiana Presbytery. Jason, y'all said this was internally inconsistent. And I think I was able to understand why. It says you may not complain, but if you do, here's how to do it.
That's right.
So an easy fix, though, for overtures.
Right. That's right.
If they so choose.
That's right.
But could you walk me through what changed this would make. I think Steve Dowling tried to help me understand it. I think I understand it, but just to make sure, explain it to me like I'm Steve Carell or a 5-year-old.
Yeah, sure. I'll try. So the way 43.1 reads now, and 43 is on complaints. So when you allege a court of the church is in error for anything, so anything the court does, you allege is an error. This is the mechanism to get the review from the higher court. So 43.1, this is the main initial statement on what is a complaint. How do we define it? When are you allowed to make a complaint? And so there's really no limitations on what you can complain against, except the current BCO has one exception. You can complain against anything if you're under the jurisdiction of that court, except that no complaint is allowable in a judicial case in which an appeal is pending. So after you've gone through your trial, you've been convicted, you've been found guilty, and you've been censured with whatever, and you appeal that to the higher court, you or anybody else under the jurisdiction of that court cannot complain while that appeal is pending. So in other words, the appeal is the primary mechanism to review problems in judicial cases. Complaint is not the primary way of reviewing judicial cases. And so, but what this has done is that exception isn't as inclusive as maybe it should be. The exception is when an appeal is pending. So what that could mean is that before an appeal is filed, somebody could complain and somebody could try to take that to the higher court. And then what happens? Do you put the trial on pause while the higher court is adjudicating that issue? I think the Overture does a good job. Well, it's quoting from a concurring opinion in a previous SJC case that lays out the number of things you could complain against before the appeal is has been filed. Investigation issues, who the prosecutor is, how an indictment is worded, the charges themselves, are charges actually offenses, who's your commission, the date, all these kinds of pre-trial issues. All of these could be complained against. And then does that put the trial on hold? It just takes you into this procedural conundrum and difficult situation. So the SJC has held on a number of occasions, I think at least 3 occasions in the past, 5 or 8 years, that this prohibition actually is a prohibition for any complaint against any part of the judicial process until the appeal is resolved. And so they don't allow what's called interlocutory appeals, where before a case goes to trial, you take an issue, a dispositive issue, up to the higher court to rule on that before it comes down. I'm sorry, I haven't dumbed this down like I should have dumbed it down. I'm trying to walk through it logically, and I didn't quite dumb it down the way I should. But so the question is, when can you file a complaint against judicial process? And what they're trying to say is that you can only do that. It can only be adjudicated after the appeal is adjudicated. So the appeal takes precedence over a complaint over the same matter. And I think it's helpful. I think it's needed. I just think we can clean up the language a bit in Overtures this year.
And so, I'm sorry, Stephen, were you going to say something?
Well, I was going to ask Jason his opinion on something, but if you want to say something first, Ryan, go ahead. Okay.
Well, I think I'll be brief. I think what you've just described is this is simply codifying what our SJC is already doing.
That's the intent, I believe, behind it, and I believe that's right. Mm-hmm.
Stephen, you want to ask something insightful?
So I don't know if this is insightful. It's more of a question because the way that this is phrased, it's talking about complaints after a process has commenced.
Mm-hmm.
So basically, complaints during judicial proceedings.
That's right.
One thing that I'm wondering is that before a judicial proceeding is oftentimes investigation,
Mm-hmm.
and investigation produces a strong presumption of guilt. Then the court shall institute process. And so the thing that I'm wondering is that, and I guess I think the most recent case cited in this particular Overtures text, the SJC didn't rule a complaint out of order because the complaint was against how the investigation was handled. Now the investigation was handled fine. There was no sign of clear error, so the complaint was denied. But I'm wondering if, and I guess it's more, I'm asking your personal opinion. Do you think that people should be allowed to complain about how investigations are conducted between sort of the institution of process? Because it's sort of the way that 31-2 is written which talks about these investigations and how they lead to cases of process and of guilt, it seems like these things could happen quite immediately, such that there's no time to file a complaint if you think there's some egregious issues with how the investigation was conducted.
Yeah, and it's hard. I think the problem is, I think in an ideal world, we should allow interlocutory appeals in very limited cases. So against the charges themselves, like the charges actually aren't an offense. Like if the charges are, you're wearing a gray shirt, you're charged with the sin of wearing a gray shirt, you should be able to complain against that charge, I think, ideally, and have those charges annulled and dismissed, the case dismissed. So I think in an ideal world, we should allow interlocutory appeals against those kinds of key issues that are dispositive in a case. Like,
and that's a real situation, with the Jonesboro 7.
That's right.
They were charged with violating the Fifth Commandment, but not told where. And there was actually an argument that Presbytery made before the SJC, either in their brief or maybe one of the guys told me about it, that if these guys didn't like the indictment, they should have filed a complaint. And there's no mechanism to do that in our current Constitution.
And Overture 21 would make that ironclad if it gets through under the intended spirit of it. It would make that ironclad that you can't file a complaint against charges or an indictment. And so I struggle because I think somebody should be able to when they're that egregious and that bad. However, our presbyteries only meet 2, 3, maybe 4 times a year. And it does significantly delay the process. So I'm of two minds of this. I would rather where we have very narrow, you can file a complaint against these 3 kinds of things as an interlocutory appeal. But the problem is they'll be abused in cases, and then you're just delaying a trial by 9 months or a year just for the presbytery to hear that complaint. So it's really difficult. And so I think this probably practically is better because say that. Go ahead.
Well, I was going to say, just to your delay, but not necessarily. You can still proceed with the trial while the complaint is making its way up to, through the Presbytery and through the SJC. And then if the SJC or the Presbytery rule in favor of they sustain the complaint, well, then everything that the trial has done is null and void. But of course, why would you want to?
Right. And that's where actually recently an SJC case, that's what happened. They kept going with the process. But then by the time it got to the SJC, they had filed an appeal. So an appeal was pending. And so therefore they said, oh, we can't do this. You've got to follow the appeal. So you kind of run out of time if you keep going too far down the process and your appeal is pending. So it's a really difficult, thorny issue. This, I think, has the benefit of simplicity and a clear, bright line rule that usually I want to go for. I want it to be clear what the expectations are, what you can and can't do. And I think this provides a bright line rule. Again, if we can clean up the language, I think we can get that bright line rule that's necessary here. Although ideally we should be able to allow interlocutory appeals, I think the bright line is probably better on balance. But it's a tough one. This is a tough one, judgment call. Everybody's going to make a slightly different judgment call. So,
indeed. All right. Well, I'm not seeing anyone rush to a microphone to argue for a speech against, so we'll move on to Overture 26 from the Presbytery, of which I am a part. I'm very fond of this overture, which would allow counsel for an accused to be drawn from any member in good standing within the PCA. Currently, if you are under process at your session level, you can have counsel from any member of that church. At the presbytery, any member of the presbytery or member of the court. So you can have a ruling elder who is also a member of the court. But only at the SJC could you have any member in good standing of the PCA as your a counsel or to assist the accused. So this certainly opens the door to a lot of hypothetical and potential issues. But I'm strongly in favor of this. So anyone want to open up with a speech against? Well, I'm not hearing any. So I guess
how about this?
Right?
I'll steelman the argument against. How about that?
Yes,
let's try to steelman it and maybe riffing off of the recent article by Jim Eggert, who is a ruling elder, and on the SJC he wrote an article that was just published by the Presbyterian
PCA
Poly
Polity
website. Yes. I think it was a good argument and made the best possible case. So I don't agree with it, but let's try to steelman it here to put
Great,
the best
thank you.
argument on the table. And I think what he's saying is that the courts of a church in a trial, they are the ones overseeing this. Oh, they're overseeing the trial. This is a procedure and a proceeding belonging to that court. So let's just use a session, for example, and a church member is being tried for an offense. And this is a procedure that belongs to the session. The session is overseeing it. The session has authority over those who are appearing before it. It is a church member only that can represent another church member because that session has authority over that church member and can make sure that what they're doing is honest, with integrity. They're doing the right thing. And so we're trying to make sure the court is actually overseeing what's going on. Now, once we have these outside influences, we have people from across the PCA, that one at that local level is really removing us beyond the local session having authority over it. You have now a prosecutor, or not a prosecutor, you have a representative of the accused who's not under the authority of that session. And so that introduces some difficulties into how the session is running things. They don't really have authority over everybody involved and over the whole process now. And then one of the consequences of that, as ruling elder Eggert brings out, is that you may then create I forget how he says it, but basically a upper level of semi-professional representatives in the PCA who are going around doing these things. And so a session who has a faithful ruling elder as a prosecutor on a case, he's going to be overwhelmed by this kind of professional level guy who comes in and now represents the accused and can walk all over the prosecutor because he knows what he's doing. And then it creates this layer of men in the PCA who are the hired guns, except they can't be paid. They are, as Jim points out, they are professional counsel at this point. They're not being paid for it, but they're professional in that they are the ones who know the rules, they know how it operates, and they're going around and acting as professional counsel, which is exactly what the BCO already prohibits. So what he's saying is, with the logic of that section of the BCO, allowing this is going to create a professional counsel class in the PCA that's not appropriate and is going to overwhelm the courts as they're trying to be faithful to these individual cases. So I think that's the best way I could summarize it. I probably didn't do it justice, but that's my best steel man.
Yeah, I think that was a good summary. Of course, it's a 3,500 word article. I would
Right.
certainly commend it to
Yes.
our viewers or listeners. I disagree, and I was texting the editor-in-chief of the PCA Polity blog today, and he said, "Well, Ryan, why don't you write a rebuttal to it?" And I said, "Okay." My concern is, we have situations in which elders know the book reasonably well and sometimes very well, whereas a church member generally doesn't know the book. And so for a church member to have the ability to reach out to Dominic Aquila, Matt Fender, some of these people Jacob Gerber, who know the book well, and say, "Look, I really feel like I'm being railroaded by my session here. Can you help me?" That's not something we would want to discourage, especially since we presume that our brothers are men of integrity. Now, of course, that then presumes something about the session. But if we want to think the best of each other, if a person really feels railroaded or ramrodded, or why would we want to say to them, "Well, no, you got to pick from," especially, the average PCA church is 100 members, or the typical, I know the average is about 200, but the typical PCA church is about 100 members. So you got to pick from these, 40 or 60 people as your counsel. That just doesn't sound fair or just.
Right.
To me. And I know there was a situation in a church that I had served. We were considering, bringing a person under process, and the session we were just struggling. Well, who within this congregation will defend that person, because that person had made such a stink. And so I think this would help the process. That session's going to be, on the one hand, more reluctant to bring charges because, they can call Dominic Aquila, they can call Matt Fender, the accused can, and say, "Hey, this has happened to me." And then, one of those experts in our polity can give the rundown and say, "Well, they can't do that, they can't do this. Let me help you." But on the other hand, if the session knows that the person will receive a fair trial and they have exhausted all of the non-procedural aspects of discipline, of which there are those, right? Then they know that well, they have access to outside counsel, even if we know they couldn't get a fair trial with counsel only from this congregation. But also, I think there's been a concern that women would be representing people before the courts or non-ordained people before the courts, but that already happens, doesn't it?
That's right.
At the session level.
That's right.
And another argument that I saw in the article, that this is a novel form of reasoning. Well, it's not that new, though, is it? Since the OPC, the Associate Reformed Presbyterian Church, and the RPCNA all already allow for any communicant member in good standing to serve as ecclesiastical counsel.
That's right. And to make the analogy to a complaint, already 43.5 lays out regarding a complaint. It says the complainant himself may present his complaint, or he may obtain the assistance of a communing member of the Presbyterian Church in America who is in good standing in presenting his complaint. So it already has this for complaints, where you can use any member of the PCA to help you, and to, I believe this is read, and that they can represent you to the lower court or the higher court in your complaint. So we already have this in the kind of the parallel process of a complaint. This is just making it consistent with the charges at the lower court, and then an appeal as it arises to the higher court from there. So I agree. I don't think it's novel, is my point there.
Okay. Yeah. Well, and to tie it into our discussion of Overture 21 regarding complaints, let's say the person was under investigation and they complained that the investigation committee or commission or what was unjustly selected. It was biased. They could complain against that.
Right.
And they could have outside counsel for that aspect
That's
of
right.
it,
That's
but
right.
not for the actual process of the trial and the appeal.
That's right. That's right. Yeah, no, I agree. I think the what we need to do is provide the accused the best resources possible to make the best defense possible. I think that's what we need to do, and I think this does it. And so I'm with you in wholehearted agreement that this is a good move for us to make. Because yes, oftentimes in these, in a small church, you don't have the resources, you don't know. And if your elders are the only ones who do know, and you only have a session of 3 or 4 men, none of them are going to represent you because they're needed on the session to adjudicate the case. And so who's left to adjudicate, to help you at the session level? The trial, the most important part of the process, you're on your own. And things like cross-examining, that's a skill. That's not just something you can read an article about how to cross-examine a witness. You need somebody who knows how to do that, who's maybe done it before. That is really helpful. It's not absolutely necessary, but it is helpful to have somebody who's done this, or at least seen it done and knows the theory behind it. So I think again, this is a good move, and I am very much in favor of it.
Well, good. Well, Stephen, in the land of professional gas pumpers, how do you feel about professional church counsel?
Yeah, I thought about this overture a little bit. Intuitively, it made sense to me. I feel like when you read overtures as they get up, you sort of get a gut feeling on them. But yeah, I mean, the Eggert article definitely it made me reconsider things. Yeah, I'm still. I only got published recently. I'm still working through some of his arguments. I do find it's I find his argument pretty compelling. I mean, he's from what I understand, he's a lawyer, so maybe he's good at making compelling arguments. I've always found his SJC opinions to be very illuminating. Always appreciate reading those. So I'm taking seriously what he says there, but also at the same time what you brothers have said. So I'm still thinking this through. It seems, Jason, that you one of the things that is mentioned in the article, which again would be great for people to read, is that our book doesn't present people from getting assistance from others. You can get as much assistance from, Fred Greco, for example, as you want currently. It's just that he can't represent you.
Well, not from Fred Greco because he's on the SJC. But
that's true. Yes.
But Matt Fender or Dan Barber or Dominic O'Quill, one of the someone who pretty much almost any of these guys, right?
That's right.
You could call one of them up. Not SJC. Yeah, Tougher Howie, Fred.
Yeah.
But yeah.
But so so the article made a point of saying that, but you, Jason, think that as you know, what really matters is that you're able to be represented by such a person.
That's right. That's right. I think they need to be able to stand up and cross-examine witnesses. They need to examine you as the accused if you want to take the stand. I think they need to do that because I think that matters. The cross-examination is critical. I mean, just how you introduce evidence in a trial, just things like that. There's basic things like that that a member of your church won't know. The average teaching elder, ruling elder won't know. You'll have to get some counsel on that if you've never done it before. And bringing in somebody who has done it before just speeds up the process, helps the process. It's not that they're going to game the system. It's just they know how to do it. And it actually doesn't gum up the process. It actually means you're going to better define the issue and get to that issue and be able to adjudicate that issue. A good advocate will help you do that. And I think that's what we're doing here is just getting the better advocate there.
Yeah.
And one of the things, oh, sorry, Stephen.
I would say that's helpful. Yeah, I think that circumstance to me, or at least what you're saying there, Jason, it makes sort of this overture seem particularly attractive or useful in situations where, you know, one party to the case definitely knows what they're doing, and the other really doesn't have much experience with what they're doing. Because I'm still, you know, in situations like that, this overture is just like, oh, it makes so much sense. But at the same time, that worry that there's just going to be representatives that are sort of the go-to representatives, like however many of them throughout the denomination, you know, that also sort of weighs on me still. I'm still thinking through that. If there was a way to make this work out such you could avoid that one thing, because that does seem like a real possible risk, which I'm worthwhile to avoid, while also fixing this specific problem.
And I've heard some say that they will to kind of help appease some of those concerns, put a cap. You can only do 3 cases a year. I think that's really difficult to, like, how you actually measure that. How do you actually enforce that? What counts as a case, or when you're consulting versus when you're appearing? Like, how do you measure any of that? I just don't think that's tenable. But I think the concern is legitimate. I think so. Already, you can consult anybody on your case, so you can already call anybody you want about it. What you can't do now is have somebody stand up and make your case for you, make your closing argument, do all of that for you. And I still think, I don't know that Matt Fender, if you call him in Tennessee, I don't know if he's going to say, oh yeah, when's the trial? Great, 2 weeks, I'll be there, no problem. He can't do that. Like, he's not going to be able to do that. The problem here is I don't think the problem of a nationalized bar is going to be an issue, because people aren't able to, for free, just drop what they're doing and go do a trial for somebody. It's going to be more local, regional people. And I think that's fine. So it's not like we're going to have 6 guys who are then going across the country and who are going to be your defense attorneys in the PCA. Because just time, you can't pay them for it. You can pay for their costs and expenses, but you can't pay them as a representative. That's kind of the ruling on that professional counsel language right now. The rule is you can't pay them for their services of representing you. So who's going to do that? Maybe some retired guys will do a few cases, but they're not going to be serial representatives doing this every month of the year. So I think the financial incentives alone indicate to me this is not going to be a widespread problem that some might think it might be.
And it would probably stay, these sort of quote unquote experts would likely stay regional. So it'd be like a presbytery would have 1 or 2 guys that people typically go to, because he can hop in the car for an hour and get to the church, which would preserve, in a sense, the grassroots character of the denomination that, in a sense, would be threatened by such a nationalized bar, as you said.
That's right.
Well, good. I'm glad we mostly agree, and I would commend that article on the PCA Polity blog to our listeners. Let's move on to Overture 26 from New Jersey Presbytery. Stephen, help us understand this one-word change that you have imposed upon, or seek to impose upon, the denomination.
Well, the New Jersey Presbytery sent up this overture. I won't comment on who wrote. Actually, I will.
We all know who runs the New Jersey Presbytery, though.
Well, it's like who wrote the Ohio one. You know, it's pretty obvious who wrote the Ohio one. It's sort of like when Howie Donahoe stands up and the overture is from Pacific Northwest Presbytery, and it's like, oh well, we sort of have an idea of who is behind this overture. But yeah, so this overture is it's just a one word change, a one word change to the RAO, because just in the process of sort of reviewing Presbyterian records last year, I was looking at stuff in the RAO and the BCR. I'm like, oh, there appears to be a very slight sort of contradiction, disagreement between the two of them, where the BCO specifies that you do something with a particular type of record or a particular type of report, and that the RAO specifies you do a slightly different thing with a particular report. So, I mean, BCO 40-5 was very much in before the assembly last year, more so than previous years, but it gives specific instruction on how you handle credible reports of important delinquencies or grossly unconstitutional proceedings. What you do with those things is that you are to, the first step is to cite the court alleged to have offended, to appear before the court having appellate jurisdiction, its commission, and then sort of proceed from there. So if you encounter a report, if a higher court encounters a report about a lower court, or rather the court next below, that is an important delinquency or grossly unconstitutional proceedings, they do this thing. You cite them to appear.
They shall. This is not a suggestion. This is mandatory language. If you deem something is an important delinquency, you shall cite them. You must cite them.
Right. And so that's what BCO 40-5 says. That's a constitution. That's the law of the PCA. RAO 16.6 tells us how the Committee on Review of Presbyterian Records is supposed to assess what constitutes an exception of substance, an exception of form, and a notation, giving categories for, you look at something in Presbyterian minutes and you say, this isn't right. Well, in what way isn't it right? And therefore, how should I report this to the assembly? If it's someone spelled a name wrong, well, then it's a notation. If certain other clerical things weren't done, it's often an exception of form. But if it's more than those sort of two lower level things, it rises to the level of exception of substance. But the thing is the language currently in the book, or the rules rather, for exception of substance includes that category that is described in BCO 40-5. So in RAO 16.6 C1, we see, and it's on the screen there, that exception of substance include apparent violations of the scripture or serious irregularities from the Constitution of the PCA, actions out of accord with the deliverances of the General Assembly, and then here's the important part, and matters of impropriety and important delinquencies. So important delinquencies are handled under 40-5, but they're also allegedly handled under RAO 16.6 C1. So which one takes precedent? Well, obviously the Constitution over the rules, and so it would be proper to sort of just bring the rules in accord with the Constitution. And as opposed to important delinquencies, which is it's a technical designation in our Constitution, and having that be what constitutes an exception of substance, or what falls under it, we should talk about a different sort of delinquency, one that isn't important, but somehow less important. But you don't want to say less important delinquency, because that would make the rule
middling delinquencies.
And again, so well, they're called exceptions of substance. Why don't you call it substantive? Because that's sort of you can't really disagree with that word because it's in the title. And so this doesn't really, I don't think, change anything about how anything is done in our polity, or even in the review of records. It just eliminates a point of confusion. What do I do with something that rises to a particular level?
Yeah.
It makes sure that you follow the book, because now the rule doesn't even comment on that.
Yeah.
It leaves it to the book.
Right. And it seems like, as it's currently written, theoretically, any exception of substance could also trigger a 40-5 if you wanted to interpret things rather uncharitably, because the language is there.
Yeah, you could say, yeah, this exception of substance is an important delinquency, therefore we're triggering 40-5, right? So that's how it currently is read. It could be read, but that was not the intent, and nobody's reading it that way. And so I think this is a good way to clarify, hey, 40-5 is like the highest level of concern. This is a lower level of concern. And so we're using a different word to indicate this is a lower level of concern than that important delinquency.
come back next year or next quarter
Yeah.
and tell us how you fixed it. We'll sell
That's
you
right.
then, type of
Exactly.
Yeah, and if in a couple of weeks, like people look through the RPR report, all like several, whatever, 150 pages it was last year, you'll see that most exceptions of substance are something that, like, important things, like, a licensure exam was not properly recorded. Like, it's important that presbyteries note that people were examined in the areas the book prescribes. But that is not as severe as some other things that could happen in a church that warrant sort of immediate action
That's
by
right.
the court, like happened last year.
Yeah.
That's right. That's right.
Well, let's press on ahead to Overture 32 from Eastern Pennsylvania, distinguishing how a man's call might be dissolved. I think this will touch on the RUF affiliation agreement as well. Do y'all have any help to see how this might be different from how we currently do things?
Well, before that, maybe if Jason would be kind enough to tell us why CCB thinks it improper for a presbytery to cite a permanent committee of the assembly.
Yeah.
That's what people understand quite
Right.
because that's what their advice is. The CCB's advice says that functionally.
Right. So a citation is an authoritative a summons to appear. So if a court issues a citation to the accused to show up to plead, that is authoritative. That is morally binding. That is something a session can do that is morally binding. Same way a presbytery can cite a teaching elder to appear if there's charges against him. It is morally binding, and you must do this. That is your obligation. You've promised your submission to this body. You must appear. So a citation is one with lawful authority calling somebody to appear before them. And so what this is actually doing is reversing the flow. Higher courts can cite lower courts, but lower courts can't cite higher courts. And so what CCB has said is that this reverses the logic, and there's no authority for a presbytery to cite a higher court to show up with that moral authority. Now, I think this could be fixed by saying the presbytery shall request the committee or agency to appear, or shall call the committee or agency to appear, something like that. But I think the citation, it's a technical designation of someone you have authority over, calling them, summoning them to appear before you.
That's very helpful and clarifying. So if, for example, the PCA Foundation has called me to be something in the PCA Foundation, and I still live here in Tennessee Valley Presbytery, my call comes from the PCA Foundation. But if the PCA Foundation realizes I'm incompetent at raising money and asking people to give charitably, and they say, "BZ, you're a nice guy, but you're just incompetent. We're gonna fire you." Right now, they can do that, right? But if this amendment were approved, they would have to explain to the presbytery, "BZ's a nice guy. He's just incompetent." And the presbytery would have to vote on whether I'm incompetent at raising money and telling people to give charitably. Is that what this is trying to fix?
Yeah, that's right. So that's right, because right now, so with PCA, I think the thrust of this Overture 32 is saying if you are employed by a PCA permanent committee or agency, okay, yeah, PCA Foundation, I think really RUF, MTW, MNA, these are probably the areas where really there's the
That's why I
bright
didn't
light.
use those examples.
I apologize. PCA Foundation, Ridgehaven. If you're working for them, they say, we want to fire you. They can basically fire you. Now we're going to work through that on how RUF handles that. What this is saying is no, they cannot fire you until the presbytery says you can be released. And so if Tennessee Valley calls in PCA Foundation for you, Ryan, and PCA Foundation says he's incompetent, under this, then Tennessee Valley could say, yeah, he might be incompetent, but that's okay. We want him to be employed. He needs to provide for his family, so he's going to keep working for you. Sorry. I think that's how this reads, and the result of what that would be.
And I see an analogy with the congregation, right? The congregation has to request. I mean, the congregation calls a meeting to dissolve the call in like manner as they issued the call. but they
Right.
still have to request the presbytery dissolve the call. And so the presbytery could come in and say, we're not going to dissolve that call. You need to work out your differences with the man. But with to continue the PCA Foundation analogy, I may just be incompetent at my job.
That's right.
And the PCA Foundation shouldn't have to keep on paying me, even though I'm incompetent.
That's right.
You know, Tennessee Valley Presbytery might say, well, BC's the best review of session records chairman that we've had, so there's no way he's incompetent. You can't fire
Right.
him. We love him. So yeah, this is, you know, I appreciate how this rests authority over a minister at the presbytery level. Man, I'm divided on this one.
But that's where PCA Foundation, the presbytery doesn't have any authority over PCA Foundation. They can't go in and say, actually, PCA Foundation, your leadership's really, wonky. Your leadership structure isn't how it should be. We want to recommend you make these changes, and we think Ryan could be a part of making that change. It can do that in a congregation and say, actually, hey guys, congregation, y'all have really messed up here. You guys work it out with your pastor. The presbytery has no authority over PCA Foundation. So they can't do that. And so that's where they can't cite them to appear. They have no authority over them. But having authority over your particular employment there is the intent here. And I think PCA Foundation is a good example to show it doesn't work in every case. Now, other cases that are more close to ministerial, like a campus ministry, that's going to be a more difficult call. But I think stress testing it with PCA Foundation is a really good example to see where I think some holes are here in this overture.
Yeah, I think there are some holes in this overture, but I think for a slightly different reason. One of which is that I think the PCA Foundation example is not actually a particularly helpful one, because I suspect that most people, and I might be wrong here, I don't know much about the foundation and how its inner workings are, but I suspect that not everyone employed by the foundation has received a call. Some of them are simply employed by the foundation, whereas certain others who are employed by permanent committees or agencies are actually called as well. So people who are, MTW missionaries are often called, and REF campus ministers are definitely called. So I think that the PCA Foundation example, it might not apply as much as it might seem, but at the same time, I do think that this overture appears to have been written about RUF. The whereas statements make that clear. It seems like the way to address the issue at hand is by more narrowly circumscribing the rule by making it about RUF. And I'm biased here. I wrote an overture that New Jersey Presbytery is deferring until next year, related to this topic, and it was RUF specific, and it was to be put in the rules of assembly operation, not PCO. So I guess I'm saying I like my version a little bit better. But I do think that the net might be cast a little bit too wide here. I'll be interested if the Overtures Committee can narrow it, because I think there's something to the intention of the overture, even though I don't think it executes on that intention particularly. I think there's holes in it that might be a little too difficult to plug.
And one caveat there, though, on your discussion of teaching elder employed by PCA Foundation, I don't know how the structure and how that works, but I've been talking with two different teaching elders recently, and they both brought up this point. The BCO Chapter 8.8.4 refers to out of bounds calls, or actually 8.8.4 doesn't, but 8.4 talks about a different category of teaching elders serving in needful works. And so we typically talk about out of bounds guys who are serving with, as a chaplain or at a Christian school or a seminary professor at RTS or something. They're out of bounds. They're out of the jurisdictional bounds of the PCA. But this needful work is actually a historical category that the old Southern Presbyterian form of government had more exposition on. And it seems to be this is related to teaching elders doing needful works within the ecclesiastical bounds of the church, but not necessarily doing those ministerial works. So, for example, like a seminary professor at the PCA seminary, right, is a needful work. It's not an out of bounds work, but it could be classified as a needful work here. So in the same way, I think PCA Foundation, a teaching elder there could be considered a needful work. And so we wouldn't call it an out of bounds call. but it could be a needful work. It's a call that he receives there, but it's a needful work. It's important for a teaching elder to be in this role, to liaison with churches or sessions or something. There may be a reason a teaching elder there would be important, and the presbytery would need to approve that. So that's an interesting thing I've recently learned about, this needful work category that might help do some work in some of these situations.
Yeah.
But Jason, your argument about the propriety of a presbytery telling PCA Foundation or any of our agencies, that's a very strong argument that as I think my presbytery had similar questions about this process a couple of years ago when a campus minister was dismissed. And, well, we like that guy. What do you mean? I mean, how can you come in? You're just down in Lawrenceville. We're right here.
That's right.
And
That's right.
This debate will be interesting if it makes it to the floor. Well, because the overtures, if they say to refer it back, there's really no way to debate it.
Right.
Which is why if it makes it out of overtures alive, the debate will be interesting. But perhaps.
And it may be preempted by the RUF affiliation agreement discussion anyway, and it may render this moot as that comes forth. I haven't seen it. I saw it was just put today in the Commissioner's Handbook. I haven't been able to read it yet, but it just dropped a few hours ago. And so that may, that if we go with that route that'll go through the RUF Committee Commissioner's Report. If we go that route, then I think this will be unnecessary if it comes to it. So we'll see. I think this is an alternative to that affiliation agreement.
And Stephen can sort out the rest of the details next year.
That's right. That's right.
All right. Well, I think we've have we made it to the end?
I think so.
Unless we're aiming to discuss presbytery absorption, because I think that's what the next couple overtures do after 32. But I don't know.
Yeah. Well, we are strictly on the process today. Wow, that's a terrible picture. Sorry, let me get that. Let me fix that. Ooh, sorry to our viewers. This is why most people listen to the Westminster Standard podcast rather than watching it. But well, thank you both for your time and your arguments. I understand things a lot better, and I've even I'm thinking I'm gonna have to rethink one or two items. So, any words in closing?
No, I think this is great. I think these conversations are important, and I hope a lot of our elders are doing this kind of thing before we get to GA, hashing it out, understanding the issues before we get there. And these procedure things can feel really distant and really theoretical, and maybe sometimes they are, but they will, in certain circumstances, they have profound impact, and these are really important things to be thinking through. So yeah, let's not just assume Overtures Committee is going to do all of our work for us. They do a significant work for us. I'm very thankful for it. But we need to think through this and be ready when these matters come before us at GA. So I think this is a great forum, and I'm thankful for the opportunity to be here and share a little bit.
Thank you. Well, yeah, and I think it's important to remember that just because there aren't these hot button, socially pressing issues before the assembly, that doesn't mean that what we are debating and discussing is less important. And in fact, I think what is before the assembly this year is perhaps even more important and significant than the overtures dealing with sexuality over the last 3 or 4 years. This will reshape how we function as a denomination, and whether we remain a Presbyterian denomination or become something else, depending on what the final form of the changes look like. Well, Stephen, any closing words?
Yeah, I think I'm grateful. I think this was I learned a lot from both you brothers today. Helped clarify some of my own thoughts, which is good, because it's good to go into the assembly with an idea of what you think on particular matters, but it's always good to always be refining the opening to hear things from other brothers who are striving to serve the same church, the same Lord. So that's really, really great. I'll also encourage people to just be talking among the people in their presbytery, the elders at their church about these things. If there's a guy at presbytery who's been going for 20, 30, 40 years and knows how things work, talk to him on the phone, go to lunch with him, get his input on some of these things, because there is wisdom to be had in that many years of assembly experience. One of the guys in our presbytery, he has that much experience, and he'll remember Back in the early 80s, certain things that happened on the floor, and you're like, oh, that's not in the minutes, is it? So it's good to find those people with their brains, but also just more generally be talking to one another, trying to really understand what's going on and see what would best serve the church, hearing good arguments from however many sides there are to an issue, which I think we did here today, because there wasn't unanimity on all of these topics, which I appreciate.
That's right. Yeah, I agree.
Thank you.
Hi, this is Thermo Beasy. Thanks for joining the conversation, which is on the Westminster Standard.
The Westminster Standard is the podcast of Jude 3. For additional resources or to make a donation, visit our website, jude3pca.org. As a reminder, the opinions and views expressed on the Westminster Standard podcast are not necessarily those of Jude 3 and the PCA. On this program, we try to bring you a variety of perspectives, and we do not edit our guests for content, but hope to foster greater dialogue and understanding as we promote the historic, old-school Reformed faith in the Presbyterian Church in America. Remember to subscribe and share this podcast as we continue to offer preparation for the General Assembly meeting June 10th through 14th in Richmond, Virginia. I'll be back next week and talk to you then. Thank you.